From the very beginning of the modern homeschool movement, the real issue was, should parents have the right to make decisions? In fact, should they have the right to teach their kids at home? And I often refer back to the Attorney General back in the 1980s in Texas. We called him Junkyard Dog Jim Maddox. He was a far-left Democrat who actually prosecuted people for homeschooling. He encouraged the TEA to do that. And this is what Jim Maddox said. Jim Maddox said, "I don't believe parents are qualified to raise their children, much less teach them at home." So when we got into the lawsuit really was the legal argument was, are homeschools really private schools? And so we spent almost 10 years in the courts where we eventually won that at the Texas Supreme Court. And the court realized, in fact, they pointed out in the court case, that in the early 20th century, most of the kids in Texas were being homeschooled. And Texas considered homeschooling as private schools in those days. So we wound up winning that case, and homeschooling, Texas went from being one of the worst places in the country to homeschool to being one of the best places in the country to homeschool, because with that court case and the Leeper decision, homeschools were now considered to be private schools, and the state of Texas does not regulate private schools. So that meant when we won that case, parents now who are able to teach their kids, all they had to do is have a curriculum that covers the basic educational goals of reading, spelling, grammar, math, and a study of good citizenship, and be pursuing that in a bona fide manner. Well, that, my friends, is freedom. So about 10 years ago, I went to the board of directors at the Texas Homeschool Coalition, and I said, guys, we have won the battle with the school districts. We have a Supreme Court decision. And now when we have school districts come after parents who are homeschooling and want to prosecute them, we threaten to sue them. And they all have legal counsel, and legal counsel says you can't do that because you have a Supreme Court decision. The law is clear in Texas. Parents can choose to teach their kids at home, and you can't stop it. So we won that battle. But in 2010, what we realized is the new battle for homeschooling was really the battle for the fundamental God-given right of parents to make decisions for the upbringing of their children. So I said to the board, I said, you have the right to homeschool unless CPS comes after you and they argue that you're not a fit parent, and now you're in court and a judge decides, I'm going to decide what is in the best interest of your child, and because CPS doesn't want you to do that, I'm going to say it's not in the best interest of the child. Or if you have a custody case with a non-parent, a grandparent, an in-law, somebody like that is suing the parent, and the judge is saying, I have the right to, in this situation, to make a decision about what is in the best interest of the child. So we began to be involved as an organization to work for parental rights. We amended our mission statement to say part of our mission is to support and defend the fundamental God-given right of parents to raise their children as they see fit. And when we talk to judges and legislators, people would say, Tim, why are y'all, this is about homeschooling, why are y'all involved in these issues? We would say because our right to homeschool is based on the fundamental God-given right of parents to make decisions for children, including their education. And if that right is undermined or limited or taken away, that affects our right to homeschool. So we began to move in that direction. And one of the things we saw, as I just described, was that every judge, and I should say this way, almost every judge in every family court in Texas believed that if there was a family in his court, and there was, whether it was CPS or a custody with a non-parent, that it was his decision to decide what was in the best interest of that child. So that meant if you're a homeschooling parent and your in-laws don't like that and they're suing you in court, then it's the roll of the dice. It's the judge who gets to decide whether or not you get to homeschool. We just think that's wrong. And we had 100 years of case law at the U.S. Supreme Court and at the Texas Supreme Court that says when a fit parent is in court against a non-parent, that the court must presume that the decision that fit parent makes is in the best interest of the child. It doesn't make a difference if the court disagrees with that. The case law said that a fit parent gets to make that decision, and the courts, you can't override that. You can't question that, and substitute your judgment that another decision would be better. So for the last 10 years, we've been working on legislation to fix that in the family code, and we continue to do that, but we've also been litigating. So some of you may remember our Let Her Stay case 2 years ago, where we got involved in a case because a fit father was divorced from his wife. They had joint custody, and in a tragic car accident, his ex-wife was killed in a car wreck. And so the dad received the custody, the sole custody of his young daughter, 4 or 5-year-old daughter. The mom had been dating a man, and she had been engaged for 3 months to this man. So this man was not related by marriage or blood to this child. And this man went to court. Actually, how this started was the father's ex-in-laws sued him for custody of the child. And the courts rightly said, you're a non-parent, you don't have standing because this is a fit father. And so the grandparents that were unsuccessful in that way got the man argued because he had lived with this woman and her daughter for 6 months. Under Texas law, he should be able to have joint custody. And a local judge issued joint custody to a man who was not related to this little girl by blood or by marriage against the fit father's will. And he had to share his 4-year-old daughter with this man. And of course, this case was appealed, and it wound up at the Texas Supreme Court. So we saw this case. This is an opportunity for us to help this father not just keep his daughter, but for us to clarify the law that the judge doesn't get to make this decision. In these kinds of cases, a judge doesn't get to, quote-unquote, decide what is in the best interest of the child if there's a fit parent with that child. And so you can go on our website and look at the Let Her Stay campaign. We raised a bunch of money. We filed an amicus brief. We got a lot of other organizations to do that. And I'm happy to tell you that a landmark case was decided, the CJC case in 2020, that clarified in a unanimous decision by the Texas Supreme Court to every judge in Texas that when a fit parent is in court against a non-parent who is seeking custody, that the judge must presume that the decisions that fit parent makes is in the best interest of the child. That was perhaps the most significant case on parental rights that we have seen in Texas in its history, and that was the CJC case. So the one thing the courts did not touch on in that case was, what is the standard of evidence in which a court overcomes the presumption that that parent is a fit parent? And what we are seeing now in the Kalanick case before the Texas Supreme Court is just such an issue. Let me lay that out for you and tell you why we're involved in that, why it's important for parental rights and homeschooling in Texas. There is a father. He and his wife were married. CPS took the child out of their home. They did an investigation. They found the mother guilty of abuse, not the father. And as a result of that investigation, they returned the child to her father because he had not been found guilty of abuse or neglect. That's a key point. The grandparents of the ex-wife now, who was found guilty of abuse or neglect. Those grandparents are suing that father because they want custody, or at least joint custody, of that child. And here's their argument. Their argument is that father does not have the presumption of fitness because CPS investigated him years ago. So do you get that? In other words, the mere fact that CPS investigated you, regardless of the fact that they didn't find any abuse or neglect, you now lose your presumption as a fit parent. That is wrong. And so that case is going before the Texas Supreme Court. The Texas Homeschool Coalition has hired an appellate attorney to represent that family in their case at the Texas Supreme Court. We are looking for, and we are going to file an amicus brief on our own in support of that father. We are looking for other organizations to do the same, because this is a battle for the fundamental God-given right of parents to make decisions for their own children. So I hope you will follow us on that as we look to support parental rights in this father in particular. Hope you'll pray for that father, the Kalanick case, and you'll follow us. So I hope you'll share this video. I hope you'll go to our website, thsc.org, for more information and how you can help us keep Texas families free.